Stop recording now. Most people comply within seconds. Phone down, screen dark. The moment is gone, and the only independent record of what happens next disappears with it. 7 federal circuits have ruled that command has no legal force. But knowing that is not enough. There is a 3-word phrase that transforms continued recording from what an officer frames as defiance into what courts define as constitutionally protected activity. 3 words that accomplish legally what silence never can. Here is what they are, and what the record shows about what gets lost when drivers lower their phone on command. The hollow command. 7 federal circuit courts have now ruled on the right to record police in public. 1st Circuit, 3rd, 5th, 7th, 9th, 10th, 11th. Everyone reached the same conclusion. The First Amendment protects it. That is not contested doctrine. That is the settled position of every federal appellate court that has weighed in. The 10th Circuit put it in plain language in Irizarry v. Yahia in 2022, ruling that filming a traffic stop falls squarely within the First Amendment's core purposes to protect free and robust discussion of public affairs and hold government officials accountable. The First Circuit said it first in Glick v. Cuniff in 2011, a case where a man was arrested for filming police on Boston Common, charges dismissed, civil rights lawsuit filed, First Amendment violation confirmed. The Third Circuit confirmed it in Fields v. City of Philadelphia in 2017, joining what the court called a growing consensus. The 7th Circuit struck down an Illinois felony eavesdropping statute in ACLU v. Alvarez because it criminalized the act of recording officers performing their public duties on a public street. The 4th Circuit confirmed in Sharp v. Winterville that live streaming a traffic stop is First Amendment protected speech. When an officer says stop recording at a traffic stop, they are issuing a command with no legal authority behind it. 7 appellate courts have said so. Why people still comply. Knowing the law and applying it in the moment a uniformed officer leans into your window are 2 completely different things. Research into compliance and authority shows consistently that people follow orders from figures in positions of authority even when those orders conflict with what they know to be true. The badge, the uniform, the command tone, the light still strobing in your mirror, and all of it creates psychological pressure that operates independently of legal knowledge. Add to that the very real calculation that non-compliance could escalate, a raised voice, a demand to exit, a hand reaching for your door handle, and the decision to lower the phone feels like the rational choice in the moment. Most people who know they have the right to record still comply when ordered to stop. Body cam footage from documented incidents shows the pattern clearly. The phone goes down within 3 to 5 seconds of the command. What those same body cams then capture is what the driver missed, because they obeyed an order that had no legal force. That footage belongs to the department. Yours disappeared. The most consistent finding across cases where recording rights were violated is not that drivers did not know their rights. It is that they lowered the phone the moment an officer said a single sentence. The 3 words you are about to learn exist specifically to close that gap. That pattern shows up in incident after incident. An officer's body cam captures a driver with phone raised, then within seconds, the screen angling away and going dark. The 3 words. Here they are. The 3 words you say the moment an officer orders you to stop recording. Stay calm. Keep filming. Say them clearly once. The words are constitutionally protected activity. That is the complete response. No speech, no argument, no lecture about your rights. 3 words that do 3 specific and distinct things simultaneously. Things that no other response, and certainly not silence, accomplishes. When the officer gives the command, you respond in a calm, level voice. Constitutionally protected activity. Those 3 words are now captured on your camera and on their body cam. Everything that follows happens in a context where you have established your legal position clearly, audibly, and without escalation. That distinction is not technical. Courts treat it as the difference between a protected constitutional assertion and a voluntary surrender of a right you had. Stay calm. Your tone should be the quietest thing in the frame. Say it once. Keep the phone exactly where it is. Do not lower it. Do not angle it away. Do not pause the recording to argue. 3 words. Then continue. The phrase, "I invoke my right to remain silent," protects you from self-incrimination. "I do not consent to any searches," protects your Fourth Amendment right. Constitutionally protected activity protects the tool that documents everything those phrases accomplish, word by word. Each of the 3 words carries specific legal weight. Understanding what each one does explains why fewer words produce a legally weaker result and why more words introduce unnecessary risk. Constitutionally. This word invokes constitutional protection without specifying a single amendment, which is strategically significant. Circuit courts have grounded the right to record on First Amendment principles broadly, covering free speech, freedom of the press, and the right to gather information on matters of public concern. No officer can narrow your invocation to a specific clause and argue that clause does not apply. The word "constitutionally" signals to the body cam and to any court reviewing the footage that what you are doing exists under constitutional protection. Protected. This is the operative legal term. Every circuit that has recognized the right to record uses it. The Fields Court, recording police activity in public, falls squarely within the First Amendment right of access to information. The Irizarry Court, Mr. Irizarry, was engaged in protected First Amendment activity when he filmed the traffic stop. Protected is not you asserting a personal preference. It is you invoking the exact legal category courts use: activity. This defeats the primary element any obstruction charge requires. Obstruction statutes require conduct that physically impedes an officer performing a lawful duty. Recording from your driver's seat is not impeding a lawful function. It is activity, and specifically, constitutionally protected activity, which means the element obstruction requires cannot be established. The obstruction myth. The most common follow-up after stop recording is, "Keep filming, and I will charge you with obstruction." Here is what that charge actually requires. Obstruction statutes across virtually every jurisdiction require conduct that physically impedes an officer performing a lawful duty. The Texas obstruction statute, tested in detail in First Amendment case law, provides an explicit defense if the interference consisted of speech only. California Penal Code Section 148, subsection G, is explicit on the point. Recording police activity in a public space is not, by itself, a violation of the law. Recording alone does not constitute obstruction, delay, or resistance. Under the statute officers most commonly invoke to justify a retaliatory stop. The ACLU versus Alvarez ruling from the Seventh Circuit addressed this at the level of statute. A felony eavesdropping law could not be applied to citizens openly recording officers performing their public duties on a public street. When you say constitutionally protected activity and continue filming from your driver's seat, not blocking the officer, not interfering with any physical action, the element obstruction requires is not present. Courts have dismissed obstruction charges in these exact circumstances. The body cam will show exactly where your phone is pointed and what your hands are doing. The Ninth Circuit and California state law reinforce the same principle. Recording that does not physically impede an officer's actions cannot satisfy the element obstruction requires. Stay calm. Do not reach toward the officer. Do not exit the vehicle. Keep filming. What silence costs. Christopher Sharp was recording Baltimore police make an arrest at the Preakness Stakes in 2010 when an officer told him to stop and hand over his phone. He complied. Officers deleted every video on the device, 24 videos, including personal footage of his son. Sharp filed suit with the ACLU of Maryland. The Department of Justice submitted a formal legal statement affirming that citizens have a constitutional right to record officers publicly performing their duties. The city of Baltimore settled for $250,000 and was required to adopt written policy protecting the right to record. What the settlement could not restore was the footage itself. The record that existed when the phone was in Sharp's hands was gone before it could matter. The outcome of the underlying encounter, specifically what the arrest actually looked like, was established entirely by what other cameras captured. Cases turn on what is in the record. When a driver stops recording on command, the record from that moment forward belongs to the department's body cam alone. Footage controlled, stored, and disclosed by the agency whose conduct is in question. When you say constitutionally protected activity and keep filming, two independent records exist. Yours is under your control. Your body cam and their body cam both capture the same stop. The footage that continues rolling after those three words carries more evidentiary weight because it is documented as continuing under an explicit assertion of constitutional right, not as a default or accident. State exceptions. Everything in this video rests on First Amendment federal precedent that applies as a floor in all 50 states, but state law creates meaningful variations. Illinois, Colorado, Hawaii, and New York independently protect the right to record public police activity through state constitutions or statutes, in some cases going further than the federal baseline. Maryland statute explicitly prohibits officers from interfering with citizens recording police in public. California Penal Code Section 148, subsection G, makes clear that recording police in a public space is not obstruction under state law. In two-party consent audio states, Massachusetts, Florida, Pennsylvania, and California among them, where courts and legislatures have carved out specific exceptions for recording police performing public duties because officers working in public have no reasonable expectation of privacy in what they say in the course of their official functions. The exception to watch for in any state, recording in a genuinely private space or recording in circumstances where a confidential informant's identity could be compromised. At a standard traffic stop on a public road, those exceptions do not apply. If you want to confirm the specific statutory language in your state, do that. But the federal floor applies everywhere, and 7 circuits have now confirmed it. Your record exists. The pattern of what happens when drivers lower their phones is documented. The Electronic Frontier Foundation has cataloged cases where officers destroyed devices, deleted footage, confiscated phones on roadside stops, and demanded deletion on threat of arrest. In every one of those cases, the driver had a right that was intact the moment the officer said, "Stop." What the driver did next determined whether that right produced a record or disappeared. The 4 phrases that protect you at every traffic stop apply here in full force. Am I free to leave? I invoke my right to remain silent. I want an attorney. I do not consent to any searches. And now you have 3 words that protect the tool that makes every one of those phrases mean something. Constitutionally protected activity. Stay calm. Say it once. Keep filming. This is educational content only. For guidance specific to your situation, consult a qualified attorney in your state. Like this video, subscribe so this constitutional education keeps reaching you, hit the bell, and share it with someone who needs these words before their next stop. And subscribe right now so you never miss analysis like this. If you want to document your traffic stops from inside the vehicle where it counts, VIOFO is tagged below. 2-channel covers front and rear road. 3-channel adds the interior camera that records exactly what happens at your window. Code traffic stop saves you $10. Keep both cameras running. This information belongs to every driver on the road. If you believe that, hype this video so the next person gets these 3 words before they need them. You now know what to say when the command comes. Say it calmly, keep filming. Knowledge that stays in your pocket is the only kind that actually protects you when the lights come on.